Well, we do have this filing from District Attorney Fani Willis basically insisting on trying all 19 defendants in the state of Georgia versus Donald Trump case together. She says the state maintains that all the defendants shall be tried together. She stresses that the law favors trying all of the defendants together. She says, Fani Willis says, the trial of 19 defendants would be feasible within the Fulton County Courthouse, whereas breaking this case up into multiple lengthy trials would create an enormous strain on the judicial resources of the Fulton County Superior Court. The state is capable of trying a large and complex case. For example, the Atlanta Public Schools case began with 35 defendants, 13 of which were eventually tried simultaneously. Fani Willis goes on to make the point that should this court grant pending severance motions, a potential consequence could be a cascade of additional speedy trial demands emanating from the severed defendants. Each of those demands could spread out over the coming weeks, forcing the Fulton County court system to simultaneously accommodate 3 or more trials on the same facts before 3 or more sets of judges and juries. Realistically, holding 3 or more simultaneous high-profile trials would create a host of security issues and would create unavoidable burdens on witnesses and victims who would be forced to testify 3 or more times on the same set of facts in the same case. The pleading goes on to make the point that the possible appeals on that Mark Meadows is making, which we will discuss also in a moment, are moving very quickly, so that those appeals about moving the trial to federal court might be disposed of very, very quickly in this case. The Georgia case now is the biggest, most complicated case against Donald Trump, and it is moving faster than any other criminal case against Donald Trump, as tonight's filing and others show. And the federal courts intend to keep it moving fast, apparently. The 11th Circuit Court of Appeals is rushing now to consider Mark Meadows' appeal of federal judge Steve C. Jones's decision refusing to allow Mark Meadows to move his trial to federal court. The 11th Circuit Federal Court of Appeals gave District Attorney Fani Willis a deadline of noon tomorrow to file a reply to Mark Meadows' appeal, which includes a request that the progress of his case in the state court be paused while the federal appeals court is considering his appeal. But the speed with which the federal appeals court is responding could make a pause completely unnecessary. The federal appeals court is also asking the district attorney and Mark Meadows' lawyers to address a very simple question about the federal law on moving a case to federal court, a question that has not come up before. The appeals court is asking the lawyers to answer this question: does that statute permit former federal officers to remove state actions to federal court, or does it permit only current federal officers to remove? In a filing with Federal District Court Judge Jones, who denied Mark Meadows' motion to move his case to federal court, District Attorney Willis said that Mark Meadows was very unlikely to succeed in his appeal of Judge Jones' ruling, and that the claim that Mark Meadows could be unfairly harmed by the case going to trial in state court before the federal appeals court rules was extremely unrealistic. District Attorney Willis said the defendant is already seeking expedited procedures on appeal, and even the most optimistic timeline for his trial in this case would not see a verdict reached for months. Donald Trump's criminal defense lawyers have filed a series of motions based on the work of other lawyers in the case representing co-defendants. The Trump lawyers filed a motion to adopt co-defendant Giuliani's preliminary motion to quash and a motion to adopt co-defendant Chesebro's general demurrer to count one, along with a motion to adopt co-defendant Chesebro's motion to dismiss the indictment and a motion to adopt co-defendant Ray Smith's motion to quash indictment. Donald Trump's lawyers have indicated they might eventually file a motion to move his case to federal court, but by the time they do, it is possible that the federal appeals court will already have ruled on Mark Meadows' attempt to move the case to federal court. And so Donald Trump might not be able to create as much delay as he might have hoped with motions like this. Today, Fulton County Sheriff Patrick Labatt explained to NBC's Blaine Alexander why it was important for Donald Trump to be processed the same way everyone else arrested in Fulton County is processed.
For me, it was understanding that, again, we have a community of black and brown people that we have 3,600 detainees. 85 to 90% look like you and I, and they don't have that choice. We don't give them that choice. And they are simply accused of a crime as well. And so this accusation, this indictment, really at its highest level, I have a responsibility to our community to make sure that we are equal across the board and what that looks like. Have I received death threats because of it? Absolutely. Absolutely.
Leading off our discussion tonight is Glenn Kirshner, former federal prosecutor, and Joyce Vance, former U.S. attorney and a professor at the University of Alabama School of Law. Both are MSNBC legal analysts. And Glenn, let me get your reaction to this filing by Fani Willis tonight, just within the last hour, saying, once again, all 19 defendants should be tried together.
You know, she makes a powerful argument, Lawrence, and I have been skeptical. I think, as many of my colleagues, including Joyce, have been, of the prospect of taking 19 co-defendants to trial at the same time. But I am beginning to be a convert because, as you emphasized in your opening, when I was just quickly reading through this motion, and she said if the court were to grant severance motions, it could result in a cascade of speedy trial demands, forcing the Fulton County court system to simultaneously accommodate 3 or more trials on the same facts before 3 or more sets of judges and juries. And I have to tell you, the only thing more daunting than the prospect of trying 19 defendants at the same time is simultaneously trying 3 batches totaling 19 defendants at the same time. You need 3 sets of prosecutors, 3 juries, 3 full complement of court security members. It really feels like it is perhaps the wiser and certainly the more economical approach to try all 19 together. And DA Willis has repeatedly insisted she can do it, she's ready to do it, and she is now highlighting to the judge why it is perhaps the best approach.
Joyce Vance, what I can't understand, even having gone through this filing, is how you can try all 19 together when some, very few so far, are asking for a speedy trial, demanding a speedy trial. It is their right. And others specifically asking not to have a speedy trial.
Yeah, I think you've hit on precisely what's going on here, Lawrence, because like Glenn, I had questions about the wisdom of insisting that all 19 go to trial together. As you point out, some want a speedy trial, but others are bound to claim that they were forced to go to trial before they were ready, and that's a problem on appeal if there are convictions. So here's what Willis does in this motion. Now we understand she doesn't really want the 19 to all go to trial together. Here's the deal that she wants. She says that these 17, many of whom are now coming in and filing motions to sever, are not giving up their Speedy Trial Right Act. So they could be severed, turn around and file a motion for a speedy trial. And that's how you would get this cascade where she might be having to try this same case 3 times simultaneously, 3 different courtrooms, same witnesses, but different defendants. So she's saying to the judge, look, you've got the right to demand that as a condition of granting severance, these defendants have to waive their right to ask for a speedy trial. And then she ends up with 2 groups. The 2 and perhaps 17, perhaps 2 smaller groups down the road, but there's not this problem of overlapping trials. Georgia has some real aberrational rules. Fani Willis understands them. This is a strong strategic move on her part.